Thank you for being with us, Mr. Narasappa. It has been a great pleasure to interact with you today for Bar and Bench, a special series where we interact with senior advocates. From setting up and starting your own firm to being designated as a senior advocate, how has the journey been so far?
Well, I mean, it's still a very short period of time since I've been designated as a senior advocate. So, I think the journey since being designated as senior advocate is only a few months now. So, I think maybe we should have a chat like a few years from now to see how that journey goes. But the journey, I mean, since the beginning of Samvad, in its earlier avatar as well, it's been quite, I would say, different from the regular paths that we see the majority of the senior advocates take. I'm not trying to distinguish them. It's just how my journey has been, because I was primarily doing corporate transactions for many number of years. And then about 8-9 years ago, for a variety of reasons, I also started doing a lot of litigation, and mainly public interest litigation, and then later on, some commercial litigation as well.
Okay.
So, and then of course you're aware that I'm also the co-founder of Daksh, because of which my interaction with the judiciary has been more from a policy perspective as to how the judiciary as an institution works,
Okay.
And not just as a practicing lawyer before the court. So, in a way, becoming a senior advocate is the coming together of the two different things I was doing, both in terms of the work that I was doing with Daksh, and of course, the practice of law itself. So that way, the insights that I gained from practicing law helps in developing the agenda of Daksh, which is to study the judiciary as an institution and how it functions. And the work of Daksh also helps me in my to gain insights into the practice of law, because then you know how the judiciary works.
Right.
So in a way, it's a good confluence, if I may say so, and it's been, as I said, a different journey, but a very very satisfying one for me.
How has the transition been? Have you severed all ties with Samvad?
Yes, and it was a tough. That is it's been a very, very tough decision, and because Samvad was set up as a professional firm, it was conceived as a partnership of equals, and so I don't have any personal relatives in Samvad. Right? I mean, they're all professional colleagues, friends of course, but professional colleagues, and it was a true partnership in that sense. So while as you're aware that there's no strict requirement that you cannot practice as a partner in a firm after you become a senior advocate. I mean, there's nothing written in black and white in the law, but the practice in different cities has been different.
Okay.
But given the way Samvad has grown and that we are in 5 different cities, we decided it's best that I leave. So March 31st was officially my last day in Samvad, and from April 1, I'm an independent practitioner. Of course, my emotional relationship with Samvad will stay forever.
So, was counsel practice always the plan?
No, it is not. And in a way, see, the way my practice has developed over the years, part of it has been by design, part of it happens because, you just do whatever interesting comes along,
Okay.
right? So, for example, I set up Daksh and Samvad at the same time. And while one always hopes for the entities that you set up to be very successful, you don't plan for their journey. You can't sort of determine the journey from day one. But the way both institutions have grown has meant that you get to do different things, and you also sort of you're opportunistic about certain things in the way the practice develops, or the way the policy institution develops, and the work that you personally do. So there's a work of the institution, and then the work that you personally do. And as long as all of them are going in the same direction, then it's fine. So counsel practice was not the idea, was not the goal, say 15 years ago when I started, Samvad and Daksh, but it just evolved that way. Again, partly by design and partly because of other reasons, which are sort of incidental. As I said, the development of Daksh into a sort of an institution that studies the judiciary and also doing some public interest litigation, and then also commercial litigation sort of came together in a way that I did not foresee too much.
So in a 2015 interview with Bar and Bench, you had questioned the pendency figures with the Indian courts, whether they're accurate or not.
Yes.
Has anything changed over these years?
So the data is far more accurate, both for a variety of reasons. The data now, the way the judiciary collects data on cases is more automated, so it's computerized. Every case is every case that is filed, and then the progress of the case through the courts. It's all sort of captured very well in a sort of a computerized system. So the reporting has become much better, and it is also to some extent centralized through the NJDG.
Yes.
In addition to that, I think both the Department of Justice and the Supreme Court E-Committee have been very open in taking suggestions from organizations like Daksh, like VD and others who have studied the data in detail. So as more and more studies about data happened, I think the NJDG, the NJDG website also improved, both in terms of the just a dashboard, right? The initial dashboard was not very nice, but then many things have gone into what the NJDG has become today. And to that extent, I think I must compliment the successive leaders of the Supreme Court E-Committee, who have been very open, like earlier Justice Lokor, now Justice Chandrachud, and others who have been very open to receiving suggestions.
But did the E-Court committee reach out to Daksh in particular, seeking data analysis or anything like that?
So at various times, yes. I think we have worked with both the Department of Justice and the Supreme Court E-Committee in terms of how the NJDG should look like and all of that. When earlier, when Justice Lokor was the E-Committee chairperson, and now of course, and this is in terms of the drafting the vision document for the E-Courts Phase 3. Some of us were part of the committee that drafted the vision document upon the invitation of Justice Chandrachud. So, like Vidhi was there, I was Orgo from Vidhi, I was there. So we all helped in drafting the vision document for the next E-Courts project.
Okay. So research organizations like Daksh have taken some concrete steps to address the lack of data available in the public domain. And given the fact that there are other research organizations who are also working in the same field, do you think that having a consolidated database would make things easier of all the research organizations together?
See, yes, I mean, there's no doubt that a good database is useful. Okay. In what form consolidation should happen and how it should be used, I think there needs to be some discussion around that. Okay. But see, there's building a consolidated database takes a lot of money and effort. So clearly there is no point in wasting too many resources in trying to do the same thing. So if collaboration is possible, the answer is yes, and that's what it should be. But see, the problem also is, the way the judicial data is available in the public domain. Many things, many aspects of the data is not easy to collate and put it into a database. It requires a lot of effort. And different people have taken different approaches to doing that.
Okay.
That's why I think you may not find one single database at the moment, because the data is large. I mean, it's a large set of data. Right? I mean, if you look at the court system, I think you're talking about a huge amount of data, and it's not possible for any single organization to say, I'll create a consolidated database at the moment. That is currently the only entity that can do it is the NIC, because NIC is running the e-court system at the moment. For somebody else, that is a private policy organization or research organization, either like Daksh or there's something called Data Lab now, Justice Data Lab. For any one entity to say that they will create a consolidated database, I think it's going to take some time. It's not an easy process, but it's possible, and cooperation will certainly help to build a consolidated database. It also depends on how much more data the NIC makes public and in what form. And I think that's the key.
Okay. So given how multifaceted the issue is of pendency, it requires the participation of several stakeholders, which also includes the bar and the bench.
Yes.
How do you get to have all these stakeholders make a concerted effort to tackle the issue of docket explosion?
See, the problem with the docket explosion and efforts to resolve the docket explosion is that there is no single owner of the problem.
Right.
Okay. And again, because we started with in this interview, we started by discussing, how my journey has been. And to some extent, I have an advantage because I not only practice in the courts, I also study the problem academically through Daksh. And if you look at it as a practicing lawyer, while I may be concerned with the delay in each case, I don't necessarily have a great view on the problems the system faces. Okay, my focus as a practitioner is to ensure that my client gets the best result.
Right.
And in the shortest possible time. But sometimes the nature of the system is that if you are benefiting from an interim order or a delay helps your client, then you sort of take that route. And that's a practitioner's compulsion. But also the bar is also very diverse, right? I mean, the practice of law in the Supreme Court or in the high courts, the larger high courts, is different from the practice of law in an official court. So the compulsions each practitioner faces in terms of how he deals with his case in court on a day-to-day basis is different. Not everybody is incentivized to get a result or an outcome of each hearing. Right. See, docket explosion is not necessarily number of cases being filed. Right? Docket explosion is linked to how long the case goes through in the system. And if there is an outcome on each hearing date, then the problem of docket explosion will be solved to a large extent. Right? But there is no guaranteed outcome of any hearing. That's the most obvious thing about our legal system. So if I have a case today, I go to the court, you don't know what's going to happen. Whether it's going to, all options are open, right? It could be heard. The judge may not have a time, the court may not have time, the other side may take time, you may get stuck in some other matter and you may not turn up, or all parties are there, the judge also wants to hear, but something else comes in the way, right? So, the uncertainty around every hearing is the name of the game, right? There's no certainty of hearing of any matter on any given day.
Right.
And that's the problem. And to solve that, you need, as you write, your question sort of indicated that, you need the cooperation of all the stakeholders. So it's the registry, it's the practitioners, it's the clients, and particularly in trials, it's also the witnesses, it's also the parties, the police in criminal matters, and then the judges as well, right? So you need cooperation of all of them. But apart from this, you need the cooperation of the mechanism behind the judiciary. So for all of these stakeholders to sit and think and solve the the docket explosion problem, there is no one single entity that is focusing on it, right? So unless there is ownership of the problem in one entity, and that entity is given the authority to suggest measures and implement. See, now we have written many reports. I mean, the Supreme Court has not only directed the commissioning of reports, it actually has passed orders also on what to do with different types of docket explosion. Many high courts have also done written judgments on how criminal process should be, how civil process should be, timelines, all of that, right? So it looks like everybody knows what the solution is. But nobody is actually trying to implement the thing, right? But again, this is a very generalized statement. There are exceptions. There are different experiments and pilot projects that have been conducted in different parts of India where, some good results have come out. And again, the recent Orissa High Court's annual report
Yes.
is a fantastic effort. Right, and actually, if we start from there, we teach, we're taking that report as the base and trying to identify the motives and interests of different stakeholders, then that may be a good start. But again, it's because one court or one chief justice took the initiative that report has come out. Now, whether it will continue, we don't know. After the chief justice changes, right? So that's what I mean by saying that there is no one organization that owns the problem.
Right.
And here my sympathies are with the judges also, because judges own one problem, which is that they are responsible to decide the cases that come before them. They don't actually have time to think about the judicial system as a whole. But unfortunately, because of they have gone to the extreme they've taken judicial independence to the extreme in managing the judiciary also. It has become their problem, but they're not able to deal with the problem. And I think the executive is more than happy for the judiciary to stumble along when it comes to dealing with docket explosion, because it benefits the executive. Right? A slow functioning judiciary benefits the executive. That's the nature of the relationship between the executive and the judiciary. So we need to find or create an institution that owns the problem and is tasked with the responsibility of implementing changes.
Just a connected question to this. There is an increasing thrust on alternate dispute mechanisms. Even the Honorable Chief Justice of India has time and again in several conferences spoken about arbitration, mediation, conciliation to be adopted. But inevitably, most of these cases end up in appeals before the regular courts of law. So, is it really helping in unclogging the choked justice delivery system that we have?
See, yes and no, right? Because we don't have data as to how many cases go to arbitration, conciliation, mediation. There is no data. If a case enters the system, we have some data around it. But how many problems that can result in cases in system arise in society and how many of them actually end up in the courts, we don't have any data.
Yeah.
For example, you and I may have a contractual dispute. Again, there are many options there. One party may just say, forget it, the system is too clogged up, this claim is not worth it. It may be claimed for 2 lakhs. So it's not worth my time, I'll just ditch it. Or we may find a friend who talks to both of us and resolves it. Or as it happens these days, there may be a criminal complaint filed. Or it may actually end up in arbitration or going to commercial court or any court. Even if it goes into arbitration and we actually appoint the arbitrator and the arbitrator gives an award, and if one of the parties against whom the award is passed follows the award, then that also doesn't come into the system in the sense that it's not documented.
Right.
So today we don't know how many arbitrations there are in India. Right? There's no number because there is no institution that's studying or collecting data about the arbitration. Right? So to that extent, there is a problem in we don't know how successful they are. So that's the first point.
Okay.
The second point about what you are saying is whether they end up in appeals, and that's a serious problem, right? And that is why even though the arbitration may finish in 6 months, then the challenge to that arbitration then takes another 5 years, then it's a meaningless.
And then you have plethora of applications.
Yes. It's a
questioning the seat, the award.
Yeah. No, even to appoint the arbitrator. The number of section 11 applications in High Court, and the time those applications take at times, not every time. Sometimes you're lucky it gets, disposed of within a month. Sometimes it takes years together to appoint the arbitrator.
And now even the fees, I think, of arbitrators.
Fees of arbitrators. So there are many problems with that. But see, the question is, there are 2 things, right, when you're talking about the judicial system. We should not be, I firmly believe that if a right of a citizen is violated, not fundamental rights, even a contractual right, that citizen is entitled to enforcing that right. And that's what, any system that claims to implement the rule of law should guarantee. And there is uncertainty about that today, because of which the right itself has become questionable.
Right.
Okay, in practice. And there is a serious threat to the rule of law. Therefore, if you are propagating ADR just because the judicial system is clogged, then there is a problem with that approach. Right? You can't, if somebody chooses ADR because they believe in it and that it is, it's a better way of solving things, that's a different issue. So if, for example, if you are, many times we see, even as a practicing lawyer, the case has been in court for 10 years. And then the judge says, why don't you try mediation? And then, I think it's a failure of the legal system that after 10 years of being in court, you are being asked to mediate. Okay? The people are so desperate that they will settle it then. According to me, we should not, even entertain that kind of a solution. But because the system is, we are also desperate to solve things, we are going. But if parties prefer to go to ADR on day one, that's a different choice, right? And we don't have, as I said, enough mechanisms to support that at the moment.
Okay.
There are different high courts, different states have different examples. But I think unless there are many institutions that can support individual arbitrators, individual mediators, it's not going to work.
Okay.
But is it something that we should pursue? Absolutely. See, because the way it is also the legal system claims primacy or exclusivity in terms of delivering justice. Right? When we are not being able to do that, I think other methods will obviously gain popularity.
Yes.
not all of those methods are something that we should encourage, but some of them we should encourage. But again, ADR at what stage is the key, and that is my concern. But we should. I mean, it is certainly something that we should promote in a way, because it can address the challenges of the judiciary, right? Because we are not able to see. I mean, there's a lot of talk around our judges. The number of judges should become 30,000 or 40,000, or even sort of 50,000. Some people say it should be 100,000 just population ratio and all of that. But of course, judge population ratio is not in my view, not a valid methodology. It's more judge case ratio. But nevertheless, even if we want to increase the number of district judges currently, district judiciary, there's about 22 and odd thousand judges. Okay, there are vacancies. There's only about 17 or 18,000 functioning. I think it varies. Sometimes it goes up to 20. It comes below that. But sanctioned posts are about 22 and odd thousand.
Okay.
Even if you want to increase that to 30, the physical infrastructure that is required for that increase is immense. And that we, as a country, we may find it difficult to meet that challenge. So we should try to adopt new things, new methodologies like online dispute resolution, which doesn't mean, mediation all the time, but, using technology without compromising on, guarantees of natural
Do you think artificial intelligence has a future in Indian judiciary?
See, artificial intelligence is a very misused word in the current context. If it is artificial intelligence enabling the judge to make decisions better in terms of improving his ability to deal with the caseload before him, yes, the answer is yes. But I think we are far cry away from saying artificial intelligence will help decide cases in terms of outcomes. I think that's just I think these are all fancy words which unfortunately sometimes the judiciary is getting carried away with. I think we should focus on the real problems and there are many other technical tools. I mean, just in terms of, a simple thing.
Yeah.
Just in terms of why should there be, and this is like, many of us lawyers discuss. See, if a judge has 80 or 90 cases listed before him, he's not going to be able to listen to all the 80 or 90 cases. Right? It's simple. It's simple. And there's nothing, artificial intelligence has got nothing to do with it. A human being, a human judge, cannot take 80 to 90 decisions, optimal decisions in a given day. So how do we ensure that all of us benefit? So how do we reduce, for example, 80 to 90? From 80 to 90, how do you reduce it to 30? But there's a challenge there. It's easy to say list only 30. What about the other 60? That is also urgent, right? That's also important. So that is where we need technology to help in deciding, in optimizing a judge's time. That is where we can actually apply technology usefully in terms of helping a judicial officer across the country manage their day efficiently.
Okay.
If we use that, I think we'll go a long way. Hey, getting artificial intelligence to help the judge make decisions, I don't think we are anywhere close to that. I think that's just fanciful talk. Yeah.
Just one question that comes to my mind is you have such in-depth experience of corporate and commercial litigation.
Yes.
And you appear before a number of benches, judges, etc. Do you think there is a pressing need for judges to be trained in corporate law, commercial litigation before they hear such complex matters?
See, I won't say there's need for training. See, learning is something that is constant, right? So, constant, continuous, professional education is something that is always welcome. So, I'm not going to say no to that. But I would make a different point. I think we need a diverse judiciary. When I say, what do I mean? One, of course, is, gender representation. That's one thing. But even in terms of practice representation, we are a long way away from recognizing the changed nature of the legal profession.
Okay.
Right? So, for example, cases relating to technology come to courts. Now, you cannot expect a lawyer or a judge who's never dealt with technology to deal with it as an expert on day one. It's not going to be possible, right? So, how do you ensure that there is ability within the judiciary to deal with different kinds of cases? By ensuring that the people from diverse practice areas become judges. That is not happening because our judiciary is in a way because the way we appoint judges, it's fairly uniform in terms of background, right? I mean, what a person's trajectory in terms of practice before the court, how many years. So you have, say, a lawyer who, say, a person who enters the profession at 23 or 24 and then basically lives within the legal system for the rest of the profession, right? And then becomes a judge and then. So that doesn't necessarily engender diversity of the judiciary, right? So the judiciary needs to be more open to.
So by diverse, you mean in subject areas?
In subject areas. I mean, diversity in terms of gender, as I said first, that's always welcome. Diversity in terms of socio-economic backgrounds, yes, all that is there. But even in terms of practice areas, right? Because the nature of, because we are an open society and the disputes come from all segments of society, all areas of society, say business disputes, commercial disputes, criminal, crimes, IPC, right. Property disputes. It's the same thing. I mean, you can't send, a person who's only practiced, say, corporate law. If you suddenly send a property dispute to him, he's going to be in the same position as a judge who has got experience as a property lawyer dealing with a company law matter.
Absolutely.
So, but as I said, at the same time, it's not possible because we don't have, our judiciary has not, gone down the route of having specialized judges, except tribunals, which have their own problems. But I think it's going to be a challenge. But one way to address it is through, diversity of practice areas when you are choosing judges.
Okay. So given the pandemic has drastically impacted all our lives, and the bar and bench has not been immune to this fact. But even now, while I am covering Supreme Court, there have been regular observations by the bench where the judges are keen to have the counsels appear physically before the court, not virtually. In fact, Justice Ajay Rastogi went on record to say that if you are appearing virtually, I will not be hearing the case today. So some of the senior lawyers had to cancel their vacation plans and come to the court amid summer vacations on Wednesday, Thursday to appear in the case. What I'm trying to understand is that does this, does such observations or does this kind of an attitude bode well with the amount of funds that was spent on the e-courts project and to make virtual setups, etc. What is your take to it on it?
See, there is a problem in going completely online in terms of hearings. Okay, and that problem is the way files are maintained.
Okay.
Even during the pandemic, while we had, people said, judiciary went online. But judiciary didn't go online. Judiciary had hearings through video conference. It is different from having an online court or an online
where it's completely paperless.
Everything, right? Judges had to go to court. Registry had to function. If registry was not found, because all the papers were in physical form, right? So the judges were exposed to the same amount of risk in terms of dealing with the registry. The registry was exposed to the same amount of risk. All of that was there. Right?
Registry to carry the files to the judges.
Carry the files, so there was that's why I think in my view, while some of the high courts did a fantastic job in keeping themselves, I don't think that was a great success in terms of how, justice system can't shut down, during a pandemic. And the data sort of speaks for itself. So I don't want to say anything more. But what has happened in terms of docket explosion in the last 2 years, it's almost like 100% increase, right? It's doubled. It's doubled. The docket has doubled from about 2.5 crores. It's now become 4.5 crores.
4.5.
And the privilege of video conferences were mainly at the High Courts and Supreme Court. At the district judiciary level, it was very difficult. Right? And many courts didn't function.
Did not function.
For example, even adoption cases, custody hearings, all these got delayed. Right? And so that's a separate study altogether. But what I'm saying, coming back to your question, so judges are also facing difficulty in terms of if there are, and I can understand at the Supreme Court or High Court, or even if you're dealing with, say, 5 volumes of paper, say 1,000 pages, right? And one lawyer is appearing via video conference, and the other lawyer is physically present. It becomes difficult. There is a problem. Just in terms of coordination.
Okay.
Right? So unless we have a methodology where everybody is seeing the same piece of paper, whether online or
yes.
offline. See, this happens even in offline. Sometimes the 3 files are different.
Yeah.
And then they say, okay, we'll have a hearing next time, right? So the same problem is replicated. And that's the problem I was telling you earlier also. That for hybrid hearings or completely, online hearings to succeed, we need to get other things right in terms of papers being available in a digital form.
True.
Where the lawyers and the judges are seeing the same file, same page number.
Instead of
online
sharing and all of that.
Okay, so, and see, this technology is easy to sort of implement it, in the outside the judiciary, in our, with our corporate clients when we are having conferences, there is no such problem, Even in some arbitrations where I am sitting as an arbitrator, there's no problem because we are all using the same file, right? And the technology is available. But, we have not gone there yet. I would not say that we have spent so much money and not achieved much. I would not say that because we have achieved a lot. The e-courts project has achieved significantly. But what happened was, and this again, talking to many district officers and people in the computer division and all that, see, what they were doing and are doing even now, the registry is not only being asked to maintain computer files, they are also being asked to maintain physical files. Okay? So there is no incentive to be only digital. Right? Some states are ahead and other states are behind. And this is the way our country also functions, right? Whatever you say, there's always an exception. So I have to be careful when I say they're still maintaining two files, because there may be courts where they are not doing, they have moved only to digital, and there may be courts who are maintaining only offline and paper files.
Okay.
And then what happens? At the end of the day, one registrar or one clerk just enters his data from his book or register online. So it is not digitally native data. So the mistake could be, and when you started off by asking, is data now reliable? The mistake happens at various, or not, I would say mistake, error happens at various levels.
Okay.
So we have not moved to a process.
Paperless.
But even if there is paper involved, when you file even for example your passport application, there is paper involved to some extent. But the process is digital in the sense that everything is digital. You may print something, but it is printed from a digital file.
Right.
Our court processes are not that. They are reverse. You have paper, some of it is scanned. Okay? That's it. Not all of it is scanned. So that's why it's difficult to capture 100% accurate data.
Okay.
And it's also difficult to have completely online hearings or hybrid hearings.
Okay.
Particularly for filing arguments. Because you're dealing with 2,000 pages of paper.
Actually, that's what SC has also provided.
Yeah, that is the problem. But I think it's necessary for both lawyers and judges to be open to it. Otherwise, it's not going to be a good thing.
So this is a very offbeat question, deviating from the area of practice. What we see here is that there is an increasing number of petitions filed in the High Court with religious undertones to it. Why is it happening? Is it because we seek justice from the court, or we are using court as an element to further our agenda?
See, the answer is always somewhere in between. So again, there are two things. One, our judiciary has not really kept its hands off religion. That's the reality.
Right.
We have, when I say we, I mean the judiciary has intervened in religious processes. It started off from, dealing with issues regarding property, etc., which were rightly within the judiciary's, frame of operation. But then it has transgressed into commenting, for example, something like the essential religious practices, right? I mean, I actually find it very strange as to how, how the judiciary can decide what is an essential religious practice. I think it's very difficult. Okay, I know there is a proposal to refer it to a larger bench in the Supreme Court, but I think there is a problem with the way we have defined it, right, and the way we've approached it. Anyway, I've spoken about this in some other context, so I won't go into that here. But see, the cases that come before court is a reflection of what is happening in society. And in fact, I think it's Dworkin who says in one of his books that studying the law is actually equivalent to studying society. So it is an indication of what's happening in the larger society, that petitions that have what you call religious undertones come before courts.
Okay.
Also because our other areas or other institutions which can resolve disputes have equally failed. Right? See, even if you have, I remember, I think it was Mr. Sriram Panchu from Chennai, he was saying, even if there is a misunderstanding between two neighbors in a housing society, there is no space where we are able to resolve even a small dispute, right? So the political space is the space with which some of these things should be resolved, but we are not able to do that, okay, because of the way our political parties, the way our political parties evolved, and the lack of democracy in political parties. Okay. So unless there is more democracy in political parties, where some of these issues get resolved within political parties, and then thereby in society at large, the judiciary will be faced with these petitions. What the judiciary should do is another question altogether. And that is something, I suppose, we'll always have a debate. It's the same thing, right? In terms of judiciary is transgressing into policy decisions too much. Why? It's the same kind of...
It also to do with the bench, I believe. The judges, what do they think it does? Does it affect?
Of course, see, personal philosophy of judges in terms of whether they're seen to be activist judges or conservative judges, it's not something that we have studied that much in this country. But if you see the UK or the US, there's an enormous amount of academic studies on the propensity of judges to deal with certain kind of issues, whether they will take conservative view or a activist view, and what their background was. All these things.
I think one advantageous factor which the foreign countries have compared to us is that they at least have the time to analyze the judge. In Indian judiciary, the judge comes and goes in the blink of an eye.
No, and also the enormous amount of pressure, right, on a judge in India. is not something, I don't mean when I say pressure, not in terms of decision making, pressure in terms of numbers.
Numbers, yes.
The sheer numbers
yes.
that a judge is dealing with, I think it's very difficult to come to a conclusion on it. And you're taking then only selective cases and coming to a conclusion on his or her sort of ideological or philosophical orientation, which is not correct. Because the number of orders that a judge passes in India, I think it's difficult to do an exhaustive study. I'm not saying it's difficult to do an accurate study. You may still be able to do an accurate study, an academic accurate study, but an exhaustive study is difficult. You're right. I mean, so we don't have the luxury, and maybe as legal academia strengthens, I think they'll probably do some of this study.
I'm reaching my second last question and taking a lot of your time. How much of an impact do you think the Taxation Laws Amendment Act 2021, by which the Centre has proposed to do away with the retrospective application of the amendments to the Income Tax Act, will have on foreign investments in India?
See, I'll again answer this from a rule of law perspective. Right? Okay. One of the essential things for carrying out our activities in society is the need for certainty of law. Okay. So when I am getting, and this is true of everything that we do, and particularly true of business. So if you have to conduct some business, you want to know what the tax laws are. You don't want a surprise at every corner, right? And retrospective application of tax laws is strikes at the heart of the rule of law. Okay, because see, the point is you are supposed to carry out your business without fear and by knowing that you are complying with the law. But if the law springs surprises on citizens and businesses, that is not acceptable. I mean, that goes against the rule of law.
Okay.
So this constant chopping and changing is the problem of, again, I've spoken about this in some other context. The point is, why are there so many cases, right? Because there's so much surprise thrown at, all activities, right? We don't know what is coming next. So the point is, you're forced to react, and that also goes. And this is a point. Actually, it leads me to a slightly, divergent topic. I'm going off on a tangent, but many judges have said, listen, there is no assessment of how many cases will a certain amendment spawn. Okay, and that is something we have never done. So why is it that certain kinds of laws see more number of cases? Because the ambiguity increases for the executive. Ambiguity in the law increases, which means the room for different decision making by the executive increases, which means the cases will naturally increase. Okay, because you have to challenge it. So we have to think of creating certainty everywhere. So unless you are, if for example, the income tax, for example, can say, I won't change any income tax provisions for 5 years. Let's not, some of my colleagues at Daksh say, there should be 20 years. No change in law for 20 years. Can we promise that? At least in areas where it's possible.
Yeah.
Right? In certain areas you may have to, make changes to suit the situation. But see, if we are not able to give certainty in law, and certainty in law, or rather uncertainty in laws increases with increasing delegated legislation. If you are allowed to make rules, and the Companies Act is a classic example of that. How can you, by a delegated legislation, provide an exception to the main statute?
Yeah. Which
is what is happening today in Companies Act.
Yes.
That increases uncertainty, and that increases litigation. As a practicing lawyer, I'm very happy. But from a rule of law perspective,
yes.
From a rule of law perspective, it is not good. So, it is very good if there is a promise that there will be no retrospective taxation. But I think it's the least we should expect from a rule of law society. So I'm not very proud of it that we are doing it, but I'm happy. Okay. Because it's a basic guarantee, according to me, which we have forgotten.
So how far do you think India is from being the go-to destination for international commercial arbitration?
I think as far as we are from finding another living being outside Earth, and I'm being very, very honest. I know there is, there's a lot of, many times we say we should become a destination for arbitration. We are not. And, just this interview, it's a question that you have asked me earlier, I think shows that, in terms of uncertainty in enforcement of arbitral awards, many things, it's not.
But is it the legal complexity which is the hurdle?
No, see, we don't have an institution that can administer international arbitration. That's the first thing.
Okay.
Because even now, there are now MCA is there, now the Hyderabad Center.
Hyderabad, yes.
And it's not as if it is rocket science. Okay? So is it possible? The answer is yes. But have we created institutions? Are we creating institutions that can make us a destination for international arbitration? My answer is we are very far away. Okay? And in fact, I think, I have a different view on this. And I seriously question the need to make us an international arbitration destination. I think we should first solve the domestic arbitration problem. See, in fact, who is concerned today about the 40 lakh dispute or the 25 lakh rupee dispute? And that's the domestic arbitration. See, the average value of the domestic arbitration is about 50 lakhs to 1 crore. Most, senior advocates, including me, it's not worth our time to deal with it. Right? But that's the heart of the problem.
I'm just going to say that it becomes arbitrator fees at times in international commercial arbitration.
So we need to solve that. So the international commercial arbitration is a very small piece, in my view, of the arbitration, of the market for arbitration in India.
Right.
And I think focusing too much on making India a commercial destination for international commercial arbitration is not. No, I don't see why we should be concerned with it. I'm not, saying that we should not focus on it, but for the judiciary or not for the judiciary, for the government to say we want India to be a destination for international commercial arbitration, I think is a mistaken priority. I think we should focus on removing the many hurdles that we have in domestic arbitration. And then I think we will automatically become a destination for international commercial arbitration.
I agree with you. Actually, with reference to the question that I asked you before, I just suddenly remembered. You remember Justice D.M. Tharungatari? He was a former Supreme Court judge, and I happened to meet him in Jabalpur when I was there last time. And he told me that Debayan, I had envisioned this concept of a consultative process between the judiciary and the legislature as soon as the law is struck down. So that even if the judiciary is going to bring back the law from the dead, from the grave by an ordinance route or something, so the judiciary can give their input so that the law cannot be challenged again, or at least, the parts which have been struck down is not kind of brought up again. Like what happened with the Tribunal Reforms Act, and it's happening on a loop, like a vicious cycle it's happening. So just taking from what you said, that executive enjoys a slow judiciary and, these loopholes in the law. Do you think such consultative processes is something which is a very illusionary dream, or is something which can be possible to be done? Because I have a fear here, because we always speak about this Lakshman Rekha, or doctrine of separation of powers between the judiciary and the executive and the legislature. And I think that was one of the basic premises where NJIC was struck down. So do you think such a scenario will ever be possible where after a legislation is struck down or is read down, the judiciary and the executive can sit down on the table and discuss before a law is brought in?
See, may not be the judges. I don't think it may be proper for sitting judges to do it. But certainly lawyers and retired judges can do it. Right? And again,
Why not sitting judges? That is my question.
see, they are supposed to decide cases independently. And they can't foresee challenges to the law. Okay? So they may have read down a particular provision, but you don't know what other challenge may come. Right? So I certainly don't think that sitting judges should be involved in this process. But I don't see any harm in retired judges or even members of the bar from doing that.
A consultative process.
Consultative process. In fact, I think the former Chief Justice of India, Venkatacharya, told me that apparently when in the early 50s and 60s, at least the Karnataka bar, he said, Karnataka High Court bar, there was a group of lawyers who actually used to look at every draft bill and comment on potential challenges and suggest changes to that.
Okay.
So, but I don't know how much of that is. I mean, actually, I don't think anything of that sort happens today. I think
Not at all.
not at all, because even there's another problem, right? I mean, we don't get copies of bills in advance. That's of course the problem. I mean, with PRS and others, some solution. But again, laws are made as a surprise, right? Except for some laws like Companies Act or things where there's a long deliberative and consultative process. Some laws are passed like overnight, right? And this problem is more at state legislatures, not at parliament level. And
that was the CJI was hinting at, the rushing through laws in the parliament and the state legislature.
This is a problem. And nobody gives it a second thought as to what kind of litigation it can generate. And particularly with respect to local bodies, tax making, tax or fee imposing powers, there's an enormous amount of litigation that is getting generated mainly because of small amendments here and there. So, listen, as I said again, I'm as a practicing lawyer, I'm very happy. It keeps me busy. But from a rule of law perspective, we need to improve those processes.
Thank you so much for sparing so much time for us, Mr. Narasappa. It's been a pleasure to have you.
Thank you. Thank you
so much. Thank you.
Subscribe to our YouTube channel and click the bell icon.